All right, we have a question from the jury, and the question reads as follows. Can we have a better understanding of premeditation or deliberation, or any example that can be given? My inclination is that not to give any examples. I don't think that would be permitted. I don't know of a better definition than has already been given in the pattern jury instruction. I'll be glad to hear from you if you think there are additional instructions that add clarity to the issue.
And looking too, I would point out as we're looking, that both sides did tailor their arguments to the pattern instruction, which has been well approved by our courts. And they've had the advantage also of having a copy of it. Phone call, Your Honor?
state have any clarifying language that it would suggest?
I don't know if it's any more clear or would give them the clarity they're asking for. I'm just looking at, other case law where deliberation has been defined. I see State v. Bullock, which says it means that a killing was committed with a fixed design to kill, regardless of whether the defendant was angry or gripped with passion at the time of the act. And then premeditation means thinking about something beforehand for some length of time, however short, but I think that is pretty much what you've already given to them. In terms of examples, I don't think that's appropriate. But, I also don't think that it would, necessarily be appropriate to give some sort of dictionary definition either.
Yeah, and I'm looking over some cases that that has been sent by way of the appellate defenders actually a few days ago when I was they had reminded me of, and there's some slightly different languages in the cases, but it's relatively, I think, consistent over the years, and it does, and I think the instruction, this is not at all a criticism of the jury, which is obviously working hard through it and all. I think the instructions are somewhat clear. They've also been given a copy of it, and I'm worried that somewhat language that is somewhat different, even a little bit, when both sides relied on these instructions and making its arguments, I just don't think would be productive at this point, because I think the differences that I've seen in the cases, and I think the ones that Mr. Lively was talking about, are so small with what they have. And I just think they should be urged maybe to be re-instructed in the language that they have and urged to do their best.
Ed?
I don't see anything to offer the jury that would be clearer than the definition you've given them.
The language I'm looking at, which I don't know, it certainly is very consistent with what was read, is language, I think, from the same line of cases you were citing, Mr. Lively. Rather, it means that a killing was committed with a fixed design to kill, regardless of whether the defendant was angry or gripped with passion at the time of the act. It also means the defendant's anger or emotion was not so strong as to overcome his reason. Premeditation and deliberation need not last for any perceptible length of time. That's a slightly, in my view, that's a clearer statement than the pattern instruction that reads, it means the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. I don't know whether, I don't think it adds anything. So if it doesn't add anything, then why rephrase it? All right. I'm just going to bring them in, and I'll reread the fourth and fifth elements of the offense, of one of the offenses, and then the paragraph after the fifth element that says neither premeditation nor deliberation is usually susceptible to direct proof. So I'll just read those three paragraphs and ask them to go back and continue their deliberation. Let's go ahead and bring them out. Ask them to bring their notepads and their jury instructions with them.
Yes.
All right, ladies and gentlemen, you've sent out a question that reads as follows. Can we have a better understanding of premeditation or deliberations and any example that can be given? I'm afraid I cannot give you an example. And I can give you no better definition than the one I've already given you. And so I'll simply read that over and just you should apply the ordinary meaning to the words that you have been given, and you should use your reason and common sense in the application of those words. But these words are found in each of the first-degree murder charges so they appear several times in your instructions, but for example, on page 5, the fourth and fifth elements of the offense of first-degree murder on the basis of malice and premeditation and deliberation. So the fourth element is that the defendant acted after premeditation. That is, the defendant formed the intent to kill the victim over some period of time, however short, before the defendant acted. The fifth element refers to deliberation, that the defendant acted with deliberation which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proved by proof of circumstances from which they may be inferred, such as the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, threats and declarations of the defendant, use of grossly excessive force, infliction of lethal wounds after the victim is felled, brutal or vicious circumstances of the killing, or the manner in which or means by which the killing is done. So those are the definitions of premeditation and deliberation. Again, you should apply your ordinary understanding of those words and your reason and common sense in applying those words to the facts that you find in this case. With that being said, I'll ask you to return to your deliberations. If you have further questions, please let us know. Outside the presence of the jury, any objection to the dialogue I just had?
No, Your Honor.
All right, very well. We'll be at ease.